5, 4, 3, 2, 1.
This video is a complete training on how the Texas mortgage foreclosure process works from start to finish. Every state has its own foreclosure system, and many require a court case to foreclose. But Texas is different. Texas uses a deed of trust instead of a traditional mortgage. That deed of trust allows lenders to foreclose non-judicially, meaning they do not need to go to court unless something unusual happens. This makes Texas one of the fastest foreclosure states in the country, and understanding this process is essential for anyone working with distressed homeowners. Traditional mortgage states use a mortgage lien that requires a judge to foreclose. Texas, like many Western states, uses a deed of trust, which appoints a trustee who has the authority to carry out foreclosure without a lawsuit. That difference is what gives Texas its speed and structure. The foreclosure process always begins with one thing. The borrower stops making payments. Once a payment is missed and the grace period ends, late fees begin. At 30 days past due, the loan is formally delinquent. The servicer begins calling, sending letters, and emailing the borrower. Federal servicing rules require the lender to attempt live contact and discuss available assistance options. If the borrower remains delinquent, the process moves forward. By day 45 of delinquency, federal law requires the lender to assign loss mitigation personnel, explain assistance options, and document all attempts to communicate with the borrower. This rule applies nationwide, but becomes especially important in Texas because of how quickly foreclosure timelines move. The first official legal notice in Texas is the notice of default and intent to accelerate. Many borrowers, and even many real estate professionals, refer to this notice as the reinstatement letter because it explains exactly how to bring the loan current. This notice must be sent by certified mail. It must give the borrower at least 20 days to cure the default. It must state the exact reinstatement amount. And it must warn that failure to cure will result in acceleration. Some lenders send a separate reinstatement letter, but in practice, the notice of default is the reinstatement letter. If the borrower does not reinstate the loan during this period, the lender issues the notice of acceleration. This notice states that the entire loan balance is now due, that the loan has been accelerated, and that the foreclosure process will move forward. Legally, the notice of default and the notice of acceleration are two separate steps, even if some lenders combine them into one letter. Next comes one of the most important but least understood parts of the Texas foreclosure process. Before a foreclosure sale can occur, the lender usually replaces the original trustee named in the deed of trust by filing a substitution of trustee. This allows a foreclosure attorney or trustee company to conduct the sale. Homeowners do not receive any notice that this substitution was filed. It appears only in the public property records. Here is the pro tip. Once a substitution of trustee is filed in county records, foreclosure is no longer a distant threat. It is an active, intentional, and organized process being handled by professionals who will follow through unless the borrower stops it through reinstatement, modification, bankruptcy, or another legal method. This is one of the earliest and strongest indicators that a homeowner is heading toward foreclosure. After acceleration and substitution of trustee, the lender issues the notice of trustee sale, also commonly called the notice of sale or the NOS. This notice schedules the foreclosure auction. Texas law requires at least 21 days notice. The notice must be posted at the courthouse, filed with the county clerk, and mailed to the borrower. In Texas, every foreclosure sale occurs on the first Tuesday of the month, between 10 a.m. and 4 p.m. Before the auction, the borrower still has multiple legal options to stop foreclosure. These include reinstating the loan by paying all arrears and fees, paying off the loan in full, obtaining a loan modification, entering a forbearance agreement, starting a repayment plan, getting an approved short sale before the auction, completing a deed in lieu of foreclosure, filing bankruptcy, which triggers an automatic stay, or obtaining a temporary restraining order by challenging service, assignment, inaccuracies, or other procedural defects. Some of these options are guaranteed if done correctly. Others depend on lender approval or court discretion. If the borrower does not stop the process, the foreclosure auction occurs at the county courthouse and is conducted by the substitute trustee. The highest cash bidder wins. If there are no bidders, the lender takes back the property as REO. Unlike tax foreclosure in Texas, there is no redemption period after a mortgage foreclosure. Once the home is sold at auction, the borrower cannot redeem it. After the sale, the winning bidder receives a trustee's deed, which transfers ownership immediately. Title companies may require a waiting period before issuing title insurance, but legally, ownership transfers at the moment the trustee declares the winning bid. If occupants remain in the home after the sale, the buyer must follow the eviction process. First, the buyer serves a 3-day notice to vacate. If the occupants do not leave, the buyer files a forcible entry and detainer case in justice court. The court schedules a hearing, and if the buyer wins, the court issues a judgment for possession. After the waiting period expires, the buyer can request a writ of possession, and the constable physically removes the occupants. This completes the foreclosure and the transfer of possession. If the foreclosure sale does not cover the loan balance, the lender may sue the borrower for a deficiency judgment within 2 years. Borrowers have the right to challenge the deficiency amount based on fair market value. Texas law gives lenders 4 years from the date of acceleration to complete the foreclosure. If they fail to foreclose within that 4-year period, the lien becomes void. This is an important detail for investors working with subject to and creative finance strategies. Here is another pro tip. Even after a foreclosure, homeowners may still be entitled to money known as excess proceeds or overages. If the property sells at auction for more than the debt owed, the surplus belongs to the borrower. It does not go to the bank, the trustee, or the investor. Most borrowers never claim this money, even though it is legally theirs. Helping homeowners recover overages is a powerful opportunity and a valuable service. Here is a full summary of the Texas mortgage foreclosure process. Missed payments. Collection efforts begin. Federal loss mitigation requirements. Notice of default and intent to accelerate, also known as the reinstatement letter. Notice of acceleration. Substitution of trustee filed, without notice to the homeowner. Notice of trustee sale, also called the NOS. Foreclosure auction. Trustee's deed issued to the winning bidder. Eviction and writ of possession if needed. Possible deficiency judgment. And potential overages owed to the borrower. If you want deeper training, don't forget about the UNC 360 REI Codex School. There is nothing else like it. Joining REI Labs is another step forward to getting more real estate deals done. Remember, this isn't rocket science. You're learning concepts, strategy, some math, and how to find deals. Most importantly, you're learning to take action. Keep it simple. Keep it crisp. Keep it honest. Subscribe now, and I'll see you in the next video.